Welcome dear learners and viewers. Today we are going to discuss the topic entitled Issues related to accessibility of legal redress on human rights of various sections of people. The present course content is related to the core paper 4 of the postgraduate degree on human rights and duties in India, law, politics and society, and importance of internationalizing human rights and duties. Before going deeper into the present discourse, we need to understand the concept of legal redress. Along with this, we will try to explore why is accessibility to legal redress more important and how does this accessibility influence human rights of people. Human rights are an indispensable context of human life, and a graceful and contented life is impossible almost until and unless the basic human rights are relished during the course of living and livelihood. Some prominent human rights include dignity, liberty from any form of oppression or torture, right to expression, right to privacy, freedom to form and express opinion, right to free trial, equality before law and the like. These rights form a framework which makes human life look very comfortable, but only if they are enjoyed duly and they are redressed in case someone is deprived of them. This is where the concept of legal redress gets highlighted. Legal redress is composite of mechanisms which compensate the loss or injury to someone, restitution or recovery for harm done to someone, access to the legal institutions like courts to gain reparation of the damages if possible in the case and the like. Now, all this seems very easy in just letters, but in spirit it is very challenging. Figure 1 says it all. There are enormous laws we have which promise redress to the victim, but there is one major issue, that is endless wait. For understanding this view, we can quote example of painful references like Nirbhaya case. It was too long, after which the family of the victim got justice, and that too after immense harassment and social, emotional and legal sufferings. Moving further, the nature of democracy determines the accessibility to the legal redress. If discussed in case of India, there are many factors which affect as well as affect the legal redress mechanisms and also the accessibility to those mechanisms. Sociologically saying, there is so much social differentiation in Indian society that the whole realm of human rights and its legal redress takes a very complex and challenging form. The cultural and social variance in communities and different sections of society further bring about relativity in the content of human rights too. Human rights for one group may be violation of human rights for another group, and there may be many factors behind this variance. Sex crimes against women, children and also men, custodial deaths, honor killings, wedlock rapes, assault, robbery, killings and murders for money or for personal revenge, abetment to suicide, human trafficking and the like are such crimes which are direct attack on human rights of people. But these violations of human rights also attain different faces when the talk is driven towards community studies. Hence, there is a need to explore the factors affecting legal redress in case of human rights violation, and we shall take them in depth now onwards. Whether a person or a group gets compensation for the loss, injury or damage done to him or her or not, whether he or she is able to move to courts or other authorities to even address the issue, whether the system the victim approaches is cooperative or not, all this has to be analyzed. These are the factors which are much needed to be discussed in this context. First is gender. In India, gender is one such social determinant which affects the justice administration and even the access to the legal redress to a large extent. Gender is socially constructed out of a particular sex. That clearly means that there are some abilities and disabilities imposed on every gender. When society constructs gender or undertakes gender socialization of the individuals, it obviously means to take one inferior to the other, to understand one is inferior to the other. This inferiority encapsulated multiple domains like decision making in household, status and role in community and society at large, submissiveness to physical or mental torture, expression of the pains and also abilities, and rights to seek legal redress. The judgmental tendencies of the social forces which act as a dysfunctional social fact against the victim hamper her accessibility. If a woman complains about sexual crime, she usually faces character assessment and judgments regarding her own social grace and acceptability. The fear of the social stigma jeopardizes the women in context of accessibility to legal redress. Firstly, because they fear social labeling and hence they do not move ahead to seek justice. Secondly, if they move into the process, they are mentally harassed in the procedure followed in the police stations and the courts. The pressure of proving their victimization pushes them to discuss those things at length which once happened and crushed them in fact, but yet they are to repeat them at the cost of their own self-respect and dignity. And finally, an unsaid boycott by family or social circle is another punishment for being vocal in open. The article entitled Access to Justice and Redress, published by the UN Women Virtual Knowledge Center to End Violence Against Women and Girls, also endorses this phenomenon. It quotes the European Union Fundamental Rights Agency survey done in 2014, which states that less than 1% of women who described the most serious incidents of sexual harassment that has happened to them consulted a lawyer, a victim support organization, or a trade union representative. The statistics in patriarch society of India can be well guessed. Figure 2 shows the statistics related to crime against India per 100,000 people including women. The figure shows that even after the legal system have evolved, civil society has become more active, the crime against women have been on rise. In the recent years, we have been haunted by gang rapes and brutal murder of young and little girls, and the legal response has been very weak. There is a need to rethink on the legal redress for women on social, psychological and legal levels. Only then a society featuring equity can be attained. Taking another thread of discussion, we will talk about another one of the most surfacing factors related to accessibility to legal redress, that is illiteracy, little mixed with ignorance. Let us discuss illiteracy and ignorance. Being illiterate would never have been such a big issue had ignorance not been accompanying it. Illiteracy is being unable to read or write. We all would have heard or read many times, but how drastically it influences people's accessibility to legal redress needs sincere exploration. Many people are not aware that they have right to legal redress, and in addition, many do not know that there are legal systems existing in the nation which can help them to be compensated for the damages done to them. Legal aid is a constitutional right under Article 21 and 39A of the Indian Constitution. It was incorporated under the 42nd Amendment done in 1976. Legal aid is very important for the people who are poor. That is what can bring about justice in society for a large chunk of population. Legal aid societies in different regions are making efforts to make common people know their rights and the redress mechanism available, but still many are not aware of it and rather they are ignorant inadvertently. While taking this particular point into a deeper expansion, it can also be said that people are deprived of legal aid since they lack any legal identity. Many births in India and other nations also get unregistered and life goes on without any birth certificate. People do not realize what impact the ignorance in this context can have on the accessibility to justice and legal redress in case of any offense or crime against them. Let us discuss digital divide now. Technology is the best example to understand that no phenomena in society is completely functional or dysfunctional. Both aspects have to be seen. In contemporary times, technological means have been playing a great role in influencing the legal redress and the related mechanisms also. The whole world is knitted and the information flows from one part of the world to another part of the world in a fraction of a second. Technology makes it easy for persons in need to know where the legal help can be taken from. But there are other aspects too. In the recent COVID-19 lockdowns and a total closure of social, academic, professional activities, it has been seen that digital divide has been widened. Every home did not have an equal access to internet connectivity, but many chores were undertaken through technology, making many people deprived of already squeezed chances of development. Digital divide is another issue behind inadequate access to legal redress. Many legal aid sources operate through technology and make themselves available on just a single click of gadgets, but only for those who are digitally qualifying or trained. This affects skill development, learning and overall employability, leading to increase in poverty. Let us discuss poverty and financial disability now. According to the latest census of India, the population below poverty line was 22% in the year 2011 and 12, which is though said to be an amelioration over the 37% of 2004 and 5. In India, techniques of measuring and assessing poverty have evolved over the years with special reference to Tendulkar Committee. Brimbank Melton Community Legal Center published a global report entitled Justice Out West: Legal Needs and Barriers to Accessing the Justice System in Brimbank, that is done in 2013, in which various barriers to access to justice and legal redress have been mentioned. This report states that the persons who are disadvantaged members of society and are socially excluded groups, or those who have disability or chronic illness, are vulnerable to legal needs and legal redress. This opinion and finding is very much applicable to Indian scenario too. The poor are obviously the ones who have a lower access to justice system, including courts, lawyers and legal aids also. That makes their accessibility to legal redress very, very poor. Their financial inability makes them prone to either improper or weak access, or make them accept whatever is served in name of legal aid or legal help. They are bound to depend on the free legal aid system, which might not always be workable for the real issue being faced by them. Poverty makes people disabled in terms of travel cost to reach courts and even people providing them free legal aid, followed by managing their pastoral arrangements in and out the station region. Being poor in terms of pocket capacity imposes being poor in terms of legal redress also. Let us talk about police and moral policing. Role of police is very crucial indicator and catalyst also in the realm of justice administration and accessibility to legal redress. The first contact Any common person, in case of some damage or loss or crime done against him, will have is with the police. Police is for sure one of the major fronts on which people rely. Is the role and response from police department employees on various level efficacious? Do they do behavioral or moral policing in a way it is actually needed? Are some questions to be pondered over. Being the society's most accessible defense force, the role being played by police must act as a catalyst for upgrading the scenario of human rights and general social as well as physical security of people. Corruption is the main bone of contention here, which deprives many persons for legal redress. Another issue in this context is lack of sensitivity in police officials regarding the weaker sections of society, especially women, children and disabled people. Sociological and psychological research has found it in many research projects that there are various complexes and prejudices which develop in these marginalized sections of population. These complexes further affect their interaction pattern in society and their own cultural domains. Such persons with varied social, physical and emotional differences tend to shy and feel fear in approaching the police. Herein, special training programs should be introduced in police departments so that the ground reality and the issues of different sections of population are made known to the police authorities and they develop sensitive outlook towards crime being done against the specific communities. This shall be a great lead in enhancing the people's intent to approach and access police for legal redress. Confidentiality must be maintained, which is the need of many victims of sex crimes, which shall further add to registration of cases of crime against weaker sections of society. Let us now discuss regional, cultural and linguistic barriers. Inability to communicate in an alien nation, state or region becomes another issue of accessibility to legal redress. People who are from different areas, including migrant laborers, immigrants on national or international levels, persons not versed with a common national language to communicate and the like, are all deprived of legal redress. Figure 3 talks about the internal migration statistics in India. The figure shows that there has been a rise in number of the internal migrants in India from the year 2001 to 2011. That actually means people are from native states to destination regions which have different cultures, different language and different traits. Cultural differences make it difficult for the legal machinery of another region or society to understand and interpret the real issues of the sufferers. It also makes the migrants suffer in terms of oppression and inability to express and to be understood. Let us talk about the role of judicial institutions now. The present era is the era of judicial activism. Judiciary has started interfering in the justice administration scenario like never before. The radical role played by courts can be seen and relished in terms of people's civil, personal, environmental rights. The judiciary plays a remarkable role in expanding the realm of rights and also in identifying the gap in legislation and has performed a crucial role in context of right to health and livable environment, dignity and security of women at workplace, sex crime, medical negligence and the like. Very positive changes have been seen in these contexts. As far as the work being done by judicial institutions on higher level judicial institutions like high courts of various states and the Supreme Court is concerned, it is comforting for the people, but the scene at the local level is very worrisome. The workload in the local courts in cities is too much to avoid red tapeism. There are much more cases running in the local courts which take years and years to be solved or decided about. In many cases, the justice is delivered after the death of the person or persons who ever needed it. When people lose confidence in judiciary or judicial mechanism or judicial institutions of their nation, it results into drastic adversities. Hence, the issue needs to be resolved on various levels. First of all, there is a need to add to the number of judges so that the burden on the courts can be discharged efficiently and in time. On the other hand, establishing local human rights courts can also be of great utility. Human rights like right to life, right to dignity, right to privacy and right to physical security are some such rights which cannot be ignored and even cannot be put on long hold. Accessibility to legal redress can be improvised and increased in both quantity as well as in quality, with radicalizing the judicial institutions and the judicial workforce. Forced social change and transition is another important factor to be discussed here. History of human world has experienced social changes which occurred very suddenly and almost left no leeway to resolve to mechanisms to provide help to the victims, or we may say the sufferers. Natural calamities and natural disasters are examples of such unplanned social changes. Pandemics are another major chore to be referred to here, and the world has recently witnessed it too. In case of natural disasters and the pandemics, the flow of the losses is not predictable. It can be just recorded or estimated. During the course of the social trauma and social stigma happening to uncountable persons, there are so many legal rights which people get deprived of. Those legally supported rights are the rights to have shelter, to have food, medical care and the like. But the aspect to worry about immensely is that the speed of the administrative efforts does not often match the pace of increasing needs getting more and more complex. On the other side, the ailments and discovery of wounded or affected people moves on her side, and on the other hand, the provisions and the services start falling in trap of dearth, that is scarcity. This scenario poses a big threat to human existence on the whole. With the help of social media and other modes of media, information flows at the fastest possible rate, but the services, goods, medicines, other care reach very slow or reach never. This is the point where legal redress must ideally start working. There is a need of governmental as well as non-governmental intervention. If we refer to the drastically painful and disturbing phenomena of reverse migration that happened during the COVID-19 lockdowns, it shows us a lot of reflections of whatever we have just discussed here. The daily wage earners or the monthly paid laborers were out of jobs suddenly. A complete closure of industries led to an end of their earning, which usually is meant for their daily sustenance. They usually stay on rent, with few exceptions of those who own their own small homes. So what happened? The landlords needed the rents, but the laborers had no money to pay rent and even eat food or even take medical help in case of need for the ailing members of their family, ranging from children to old-aged people. All these things are the basic rights as citizens of the nation, but the real panic happened because they did not know the way to avail these rights. Sociologically saying, all the social changes are not planned, directed and predicted. Many a times, societal setups and institutions face sudden alterations due to financial, geographical, natural or environmental or cultural factors. But in all such situations, legal redress remains the cardinal need. There is a need to design paradigm of legal redress to people, taking in view all such unprecedented happenings so that maximum number of people can be saved from falling into an irreparable scenario of problems and issues. Educational system faced a drastic and radical change as a result of corona pandemic. This led the whole world, including India of course, to adhere to online mode of teaching and learning. One serious thing to be given due care here is that in all institutions there have been some students who could not afford having gadgets to study through online modes for months and months. The education gap which has been created between them and their counterparts who could immediately adopt technology supported means for learning is an answerable context for the administration. Legal redress was much needed here, in absence of which the developmental gap between these empowered and disempowered sections of students shall not cover up for the coming decades. After recently and so closely watching a pandemic and its impact on the social fabric, academics and legal institutions cannot avoid discussing them in the context of issues related to legal redress. While concluding out the talk, we can surely say that the whole problem does not lie in the formal system and procedures. There are many things which can be worked upon in domain of population. Awareness about what is available for the people is the most important feature which is lacking here. Let it be poverty, let it be illiteracy. Nothing can keep people much deprived of legal redress if they are aware about the legal rights they possess as citizens. Yes, the issues which might still remain are quality of redress, ability to approach or choose the right person or organization for help. Legal aid clinics are run by many institutions, academic as well as social, to help people in need. They have a handful of lawyers available too to do the task, but the condition is accessibility. Either these institutions have to reach out to people in need, identifying the regions where such lack of awareness exists, or the people themselves have to find these legal redress mechanisms through the available networks. Let us hope that India and other parts of the world improve on accessibility to legal redress so that the people who have been tortured or put on loss can find a ray of hope through the already existing laws, institutions and organizations. I hope that we all will soon meet to discuss some other crucial topic. Keep relishing a healthy and a happy life. God bless all. Goodbye.